Mr. Warnock, you may proceed.
May it please the Court. Christopher Warnock and Christine Boyer for Plaintiff Appellant Lisa Stefano. This case and its companion case, Caruso v. Apartments Downtown, present a host of important issues. This Court now has a very unusual opportunity to take a comprehensive look at landlord-tenant relations in Iowa. The first issue I'd like to start with is automatic carpet cleaning.
Could you help me just real quickly on
Sure.
the jurisdictional question on whether the jurisdiction of the small claims court was exceeded because there was a demand in excess of $5,000?
Let's start with that one. First of all, the magistrate made her ruling without doing anything about attorney fees. And in fact, she said in the ruling, oh, I don't have an attorney fee affidavit. None was submitted. So we're like, oh, well, okay, we'll submit an attorney fee affidavit. Then she refused to rule on it. So the actual ruling on attorney fees was made by the district court. So the key, though, to that is attorney fees under the Landlord-Tenant Act really are costs. I mean, Ayala and Madday make that clear. If the statute sets forth attorney fees, doesn't say how they're supposed to be assessed, they're assessed as costs. And the small claims jurisdiction is exclusive of costs. So, I mean, I think that pretty much nails that.
Generally, don't we normally have said, and I agree it's in other contexts, but haven't we normally said costs and attorney's fees are two different things?
I think the question is how they're to be treated. Attorney fees are definitely different from costs. We're not asking this case to say, oh, we got costs, so please give us attorney fees. There's a specific statute, 562A12, allows attorney fees to be assessed in a landlord-tenant case. And so that's our statutory basis. And then the question is, how do you classify those attorney fees? Are they classified as damages, as the defendant would say, or classified as costs? And I think it's clear that they're
Or
costs.
a third category, they're just attorney's fees. Because the problem is unless they're included within costs, there's a jurisdictional issue, because it seems to me at least potentially one, because there was a demand in excess of $5,000, right?
I think that if all we have, the categories we have available to us are costs and damages. And again, Ayala and Madday, they talk about that. They go into detail about these are statutory attorney fees. We don't know how to assess them. Therefore, we should treat these as costs. And that's how they're treated and assessed. And it makes sense because typically attorney fees are ancillary to the main proceeding. They're decided after the fact, not by the finder of fact, but by the finder of law. And in this case, worst case scenario, if they were damages, if that was exceeded, then okay, what? You've got to go back to the district court? We throw out the district court ruling. We certainly don't throw out the entire case because of that. The magistrate didn't rule on those. She didn't lose jurisdiction. If there was a problem, that only happened in the district court. I wish we'd never brought attorney fees up. We didn't bring this case to make money. It's become a red herring. This was never about that. I'm certainly willing to fall on my sword personally. What worries me about this is that the precedent is set that attorney fees are not granted to attorneys. And that's the problem with these landlord-tenant cases. They have not been in front of the courts in the district court level or the appellate court level because the tenants don't have the resources to do it. If we're going to worry about attorney fees, we need to be making sure that the attorneys get paid to do these cases so that they're not disappearing between the cracks. And that's what happens with landlord-tenant cases. So I would say that it would be a shame to have all these incredibly important issues that have never been raised before to be tossed out at this level on this jurisdictional issue, which I see as a red herring. I really see that the attorney fees are, in fact, costs and don't come to that jurisdictional level. And if they do, then, okay, fine, we throw out Judge Baumgartner's decision, but we don't throw everything out. That seems to me to be throwing out the baby with the bathwater. So if I may, I'd like to talk about automatic carpet cleaning. That is an incredibly important issue. Many, many leases in the state have the automatic carpet cleaning provisions. And what that says, in this case, the lease says, look, at the end of the lease, the tenants will pay a charge depending on the size of the unit for carpet cleaning, period, end of story. So no matter what, you're going to be charged for carpet cleaning. All the judges that have looked at this case have said, this issue has said, look, that charges tenants even if their carpets are clean. So what's happening, too, is you're circumventing the security deposit procedure. It's clear that you need to come in on 562A12, look at the unit, decide if there are damages or not, specify those damages, and then you also need to decide if it's for cleaning, if it's more than ordinary wear and tear.
Mr. Warnock, would the charge be all right if, I understand the potential issue here because they're taking it out of the security deposit. But would the charge be all right if the landlord simply said, at the end of the lease, we're going to clean the carpets and we'll send you a bill for the carpet cleaning?
You know, it's interesting because that follows that Stuttleberger, the Michigan case. That was a case that was just about said it was about security deposits. The problem is the Landlord-Tenant Act is a comprehensive attempt to look at the framework for landlords and tenants. And so the key for that is 562A15, which lays out the landlord's responsibilities, and 562A17, which lays out the tenant responsibilities. And so it's clear under that the tenant is supposed to keep the unit as clean as is possible. I think that's really restating ordinary wear and tear, so that the tenant has responsibility to make normal use, to do normal cleaning, but no more than that. So when the landlord comes in and says, oh, here's these additional fees, they're really shifting their responsibility. And we can't just say, oh, let's pull it out of the security deposit context and ignore the rest of the Landlord-Tenant Act, because this is comprehensive. It's trying to say, how are landlords and tenants going to work together and live together? That's what the key is to it. So pulling that out, it doesn't help us. And it certainly does fall afoul of the security deposit statute. This was specifically in the lease. It says it's to be deducted from the security deposit. So that certainly doesn't apply in this case. And as a general policy matter, it's a bad idea because it's allowing the landlords to come in and essentially rewrite the Landlord-Tenant Act. Well, we don't like, for example, in this case they argue, well, we can set the cleaning level. We can decide what ordinary wear and tear is. No. Again, the legislature and the courts get to set the law, and that's what this is set up for. Freedom of contract was clearly abrogated by this statute. This is set up to make sure that there's a fair framework because landlords and tenants are not equal. If you look at the comments on the Uniform Act, it's very explicit. We know that landlords have more legal knowledge, they have more experience. I mean, in this case, we're dealing with an undergraduate, 20, 21-year-old tenants. I've had tenants who are afraid to go forward even with counsel because they're so intimidated by the landlords. And I don't think that's unusual in this circumstance. So the Landlord-Tenant Act is meant to set up a fair framework, and I think it does do that. We're looking for nothing more than having that enforced. So when we look at automatic carpet cleaning, I think that the district court judges and Judge Baumgartner really hit the nail on the head. This is a charge that's imposed even if the carpet's clean. All of the arguments that are made by the defendant basically go to the fact that they deprive the tenant of ordinary use. What you're paying for when you get the rent is that you get to live in that unit and use it. Okay? If you're automatically going to be charged, there's a 100% chance of damage. There's nothing the tenant can do to bring that carpet up to professional cleaning standards. If you lock the apartment up, there'd be airborne dust and dirt, and it wouldn't be professionally cleaned. It's the same thing as painting it. When you paint that at the beginning of the tenancy, you don't have a freshly painted unit at the end, but that's not the tenant's fault. So again, you need to be allowing tenants normal use. And that's what the automatic carpet cleaning or any of those charges is depriving the tenant of the normal use. If you want to charge for carpet cleaning, you can do it. Put it in the rent. That's what the rent is for. So I think that that's probably the issue that has the greatest import for tenants in Iowa. Many, many leases have these, and I think that's probably has the biggest practical impact. The next issue that I think is really important is the idea that the landlord is charging the tenant for the criminal acts of a third party, an unknown third party. So this is certainly not saying that the tenant doesn't have to pay for their own vandalism, but this lease explicitly says if there's vandalism, we don't know who did it, you pay for it. And as I thought about this argument in preparation for argument, I realized that this repair shifting, I think, is a red herring. I think it's not necessary to open up that can of worms. We can look at Maslin v. Evans, in which this court said, look, if the landlord wants to charge the tenant for damage, it needs to be for the deliberate act of the tenant or negligence, or they need to know about it. And that's the only basis you can charge for the tenant. Really, the vandalism charge, that's a blame-shifting provision. That's saying, okay, we're gonna assume that the tenant did the damage. It doesn't.
Blame shifting. Neither one is at fault. The landlord was at fault, and then wasn't at fault, and the tenant wasn't at fault. We'll accept that. But hypothetically, it's a single-family house. The landlord could be living out of state.
Let's actually look at the evidence. There's a letter from the manager to the tenants. This is Appendix 78, and the tenant said, "Why are you charging us for the burglar doing the damage?" And the manager wrote back and said, "Well, you agreed to in the lease Two, the burglar, even though it's not a known visitor, is a visitor. And finally, if the police catch the burglar, we'll charge them and not you. So really, this lease provision is focused on, it's very limited too. It's only windows, walls, doors, and carpet. We know you did it. We're going to presume you did it. But if you come in with a burglar who actually
One of these kind of burglars that was sort of peculiar maybe to Iowa City, right? They were only interested in a few cans of beer and cherry-flavored vodka.
Your Honor,
there was nothing else they wanted.
I was going to say, if you lived in Iowa City, you would perfectly understand that. I mean, we have a large student population, and frankly, it's not that unusual to have this kind of burglary. And certainly the evidence at trial, the magistrate found that it was indeed a burglar. You know, and whatever the insinuations or whatever, you know, those inquiries about that, it's very clear that that's what the facts were found by the magistrate.
My question is regarding this burglary cost. Where in the statute does it allow the landlord to withhold that money at the end of the term? I mean, it's ordinary wear and tear and some other things, but where do you get the withholding for the cost of repairing damage by an unknown third party?
I think you're exactly right. There's no provision in the essentially what they're saying is if you look at what the landlord was trying to do, they weren't trying to do a general repair shifting because, again, it says paying for damage. It doesn't say for repair. It doesn't include an ordinary wear and tear either. They're really focusing on they have a vandalism problem. We want to solve it by charging the tenants for it. We're going to, essentially, we think you did it. How are they going to charge? Ask them about that.
One other question I have is that I don't think these tenants could get insurance for that because they don't have an insurable interest, and maybe I'm wrong, insurable interest on the house because they don't own it. And when they can get insurance for their own acts of negligence, and you know if they left the stove on and the building caught on fire, but how can they insure the property of another from a third person's vandalism? It seems the legislature, when they did this security deposit thing and what you could withhold and what you could charge, took that in consideration by not allowing such actions.
I think that if you look at 562A2, which lists the purposes, it says one of the purposes of the statute is that the right to receive rent is never separate from the responsibility to repair. And I think a bedrock principle of the Landlord-Tenant Act, the warranty of habitability that preceded it and inspired it, was that the landlord is supposed to be doing the repairs. And that responsibility includes paying for it, because it won't get done if you don't get paid. And that's key. There is this exception that they're using. They're saying, well, for a single-family house and also for multi-units, it's possible for the landlord and tenant to contract that the tenant perform the repairs. So I think that answers your question. The tenant needs to be able to do that repair. That's what this is all about. And normally what's used, this is used for shoveling snow, for mowing the lawn, but I can't imagine that this exception was intended to overthrow the entire landlord responsibility for repair, everything. That means you have to do
It says, I mean, the first thing we have to do is start with the wording of the statute, and it says, with a single-family residence, the landlord and tenant may agree in writing that the tenant perform specified repairs.
Right.
So
the
what's
question
wrong
is,
with that?
Well, a couple things. First of all, in this case, the tenant didn't perform the repairs. What happened was the landlord's lease says the tenant can't perform repairs. They, in fact, charge them. So that this lease fails the plain language of the statute.
Actually, as I read it, it says if they do the repairs themselves or contract themselves, but they have to get authorization to do that. They never did do that. They took the position from the very beginning this wasn't their responsibility.
No, Your Honor. If you look at the lease, it's Appendix 14, it says, repairs shall be performed by Iowa Maintenance Company, which is a business name of the defendant, the landlord, okay? And written authorization can be obtained, okay? But
And get written authorization to use someone else.
except, in this case, the tenants were never given the opportunity to repair. They were just given a bill. And that's the normal procedure. This landlord does not want tenants doing repairs.
As I understood the facts, correct me if I'm wrong, they contacted the landlord and said, you take care of it. Am I wrong there?
I don't know what the communication was. I know that they informed the landlord of the damage. When the police report was done, they informed them, okay? And my understanding is that the response back was, here's the bill for $598 for the damaged door. So there certainly wasn't a demand under the Landlord-Tenant Act. There wasn't a 7-day notice. There wasn't any notification. There wasn't any demand made of the landlord because that's not what the lease says. The lease says the tenant will pay for damage. It doesn't say we're going to give you the option to do it. we're going to charge you for it. And that's what they want to do. They do not want tenants doing repairs. They want their own staff to do it, and they want to charge for it. And their argument really basically is, look, they're doing a two-step. This tenant perform repairs, well, that's basically the same thing as us charging you to do the repairs. And it obviously is not. And again, how broad does that go? I mean, I filed a additional authorities that has a Drake Law Review article that came out fairly soon after the Landlord-Tenant Act was passed. And interesting enough, they had a very similar analysis to I had, which is looking at this and saying, no, you know, this exception, this tenant repair, doesn't abrogate the landlord's overarching responsibility for habitability, for safety, all these other maintenance. It's repairs other than that responsibility. And so that's certainly one interpretation of it. The question is, to me, it's almost like an ink blot test. How you look at that exception, it predisposes what your attitude is. I look at it saying, look, the landlord needs to keep the repairs. They need to keep that responsibility. That's a bedrock purpose. The landlord comes and says, well, we don't want to do that. We don't like that purpose. We want the tenant to be charged for it. And I think that really informs how you look at it. If we look at the statute, though, it's clear. The plain language says the tenant shall perform the repairs. So this lease falls flat because that isn't happening. Second of all, our argument would be the tenant needs to be capable of doing the repairs. If we say these 21-year-old girls, you have to do electrical repairs, you have to do plumbing, they're not capable of doing that. And there's a very significant difference in language between that. There's another statute that deals with this that talks about and I've cited in the brief, that talks about the tenant. For example, if you have a situation where the repair's not done and the tenant wants to deduct that from the rent, that language says the tenant shall cause the repair to be done. So I think there is a difference. I think that's significant. How has this been used normally? Again, it's for tenants they shovel the driveway and mow the lawn, and they're certainly capable of doing that. But to say the tenant not only charge for repairs, their argument is you can take on all repair responsibilities. You have to be the general contractor. You're going to have to go out and find someone to do this, you know, and it's also extremely broad. Remodeling. I've decided, well, from now on, I want the new tenants to pay for marble countertops for the next year. I'll put that in my lease, and you can pay for it. Roof repair. The other problem with it is the multi-units. If this is true, that you can cause all safety and habitability requirements to be put on tenants for a single family, the rationale is the same for multi-units. You just have to add an additional agreement, you sign it at the time you do the lease, and you can make every tenant in the state responsible for all safety, all repairs, all habitability. That, to me, is bulldozing the entire Landlord-Tenant Act.
Thank you, Counsel. Mr. Hogg?
Good morning. May it please the court. Counsel, I am Robert Hogg, appearing on behalf of the Appellee Cross Appellant Apartments Downtown. And this is an important case for apartments downtown, as it is for all landlords and tenants across the state. The case is fundamentally about how much freedom of contract landlords and tenants are allowed under the landlord-tenant law, and we do need clarity on that in the state of Iowa. I do want to preface this by saying it's not an issue of what's right or wrong or fair. It's what the parties have agreed to and what the statute allows. That's the legal test here. Having said that, I want to make the case initially why allowing landlords and tenants to have the agreements that are issued here are good for tenants. First of all, having a detailed lease like this apprises tenants up front before they enter the lease and after they've entered the lease of what the upfront cost of repairs and cleaning will be. That's good for tenants. That's good. Second, tenant responsibility prevents the need for landlords to spread the costs to other rental units. That is also good for tenants. Tenant responsibility puts responsibility in the hands of the person in possession of the property. That's good for tenants. That person's in a better position to control the premises, and it's why the purpose of the law is 562A.22b to encourage landlords and tenants to work to maintain and improve housing.
Well, I think some of that is absolutely right, but it depends on the context, it seems to me. Shoveling snow, lawn mowing, routine maintenance, but address the cliff argument well, I'll call it a cliff argument, and that is that you could contract away responsibility for habitability. The tenant's got to fix the furnace, got to deal with the water, got to deal with electricity, and then the end result is the ordinary obligation of habitability is shifted toward a tenant. You got a 21-year-old crawling around trying to figure out the furnace.
Well, first of all, that's not the facts of this case.
Well, but the principle, give me the limiting principle that makes it clear that we don't go there.
It's not the facts of the case. The facts of the case are the landlord fulfilled its obligation to repair. There's never been this is not housing that landlords have sat idly by. Basically, the complaint is you're doing too much to make sure the property is repaired.
Let me ask you this, under your view of the statute and your freedom of contract, and I think I understand your argument, but under your view of freedom of contract, under the statute, could a landlord say that the obligation to repair electrical systems, heating systems, water, rests with the tenant? Would that be lawful under your view of the statute?
Look, the statute prohibits 4 things. You can't waive rights, you can't shift, you can't attorney's fees, there's one other, right? It's all briefed. But there are 4 things the statute says. Otherwise, the statute says if it's not prohibited, the parties can agree. And in this case, what's been agreed to is a financial responsibility system for the specified things.
The answer is yes to my question.
Well, it's kind of yes. Remember, the landlord has the duty to make the repair under the statute. The repair was made, however the door was damaged, the door was fixed. So the landlord has the obligation to repair. Then the question comes up, what is the financial responsibility? In response to
how does this argument level the playing field if that's what the purpose of the landlord-tenant law was all about?
The law, and that's nice that you say it was intended to level the playing field. The statute meant what the statute meant. The statute says what it says, and it says 4 things are prohibited. Otherwise, the parties still have the freedom to agree. And as I was making the case, the reason these provisions are beneficial is, number 1, it's good for tenants to be clear. Number 2, financial responsibility is good because, remember, it's a balloon. If you say the landlord can't do this, rents will go up for everybody else because this is a cost that somebody has to incur. The third thing is, by having the clarity on the rental agreements and the repair fixtures, you're getting the landlord can do it below economies of scale. The record here is crystal clear that these costs are less than the costs that a third-party contractor would do. And if you look at that, I did not, just to highlight something that's not said in the brief, not brought out as well, if you look at page 59, page 36 of the transcript, it's clear that these costs are below market rates, and you have the landlord having uniform timeliness and quality. So these are good provisions. These are pro-tenant provisions.
But at the same time, the legislature has imposed legal responsibilities for each the tenant and the landlord. Yep. But then the landlord can enter into a contract to shift the cost of those responsibilities entirely to the tenant. Is that right?
Read the Uniform Residential Landlord-Tenant Act. It never says that that's prohibited.
Right.
Our obligation is to make the repairs.
You think the legislature intended that they would impose obligations on one party and then permit the cost to be shifted to the other?
I think the legislature meant what it said when it says 4 things are prohibited and otherwise the parties can agree. If Mr. Warnock's clients don't like this agreement, don't sign it. Go rent somewhere else.
Let me ask a question. When the act of vandalism occurred, was the door unusable?
My recollection is there was a 12-inch gash in the door. It needed to be fixed. By the way, in answer to your earlier, in answer to Justice Mansfield's question, the contract says the landlord's Iowa City Maintenance is going to do the repairs unless written authorization is obtained.
You're getting off on a tangent here. With that 12-inch gash, do you think the building was fit or habitable being left out in the open for that, for another burglar or someone else to get in the place?
I would say, I don't think that's been an issue. I would say personally, no. It had to be repaired and the landlord repaired it.
But, one of the 4 duties of the landlord is to make all repairs and do what is ever necessary to put and keep the premises in a fit and habitable condition. And your position is that that's one of the duties of the landlord.
Yes.
But you can shift the cost.
Yes.
But the provision that allows shift the cost doesn't say shift the cost, but make specified repairs. So what your interpretation means that the landlord shall maintain the premises in a fit and habitable condition, but then later, if we specify that's your duty, we've taken one of those 4 away.
Hey, Justice Wiggins, you've just conflated the single-family residence issue with the entire landlord-tenant law. To be clear, our position is the landlord-tenant law does not prohibit fee shifting, period. You read it, read it, read it. It does not prohibit that type of fee shifting, and that type of fee shifting is good. It's good because it puts the responsibility on the tenant closest to it, and it brings clarity, and it allows the below-market
Legislature
repairs.
should have said, as I read the statute, in your interpretation, make all repairs and pay for it, and do whatever is necessary
Well,
in order to keep it fit and habitable.
if the legislature wanted to do that, it could do that.
That's sort of absurd.
I don't think so at all, because remember, if it's not prohibited, the legislature's clear it can be agreed to. They're looking for a commonality of interest between the landlords and the tenants.
But you also have part of the language that says it's got to be in good faith. I think number 1, that's a limitation on this right of shifting in a single-family residence. Then you also have what I assume to be really something extra. I don't think it would be all that uncommon to say that you're going to take care of the window screens, doors, including exterior unit doors. But then it adds parenthetically, including the random acts of vandalism. That seems to be a special, unique, perhaps addition to the leases in Iowa City because of the obvious problems they have in not only single family but also multifamily residents down there just because of the university community. Don't you think those 2 things tied together makes this a little bit unreasonable?
No, I don't. Judge Baumgartner found, now this was in regards, Judge Baumgartner specifically found that the agreement was in good faith. This is up front. There's nothing hidden here. And it's a good provision. And it is not prohibited. Read 562A. I want you to read it over and over and over again, and you will never see anything that says you can't assign a cost to the tenant for doing a repair. You will not be able to find that. Now, if the legislature wants to change that, legislature can do that. Not the court's job.
That it's entered into in good faith.
In good faith, and Judge Baumgartner found the agreement was entered into in good faith. She makes the mistake on the carpet cleaning side, finding that there's bad faith there. The carpet cleaning provision is great. It's below market. It's a below market rate. It assures that you get the cleanliness at the end of the term that you had at the beginning.
Now you're making a fairness argument.
Okay,
right.
and
Don't we
is,
have to focus? Let me ask you on the carpet cleaning. Let's just turn to that. It does seem to me that, I mean, you could have a tenant that would use the best cleaners in the world to clean out their place. I mean, and before they left, and under the lease, they still have to pay a charge. Isn't that right?
Well, that's a reading. The record is that it is not automatic. Joe Clark says there are circumstances.
The witness said it wasn't automatic, but the lease says it is, right?
Yes, I agree with that. Here's why it's beneficial. By providing that notice, and the record's also clear that Apartments Downtown tells the tenants, you do not need to clean it because this is going to be professionally cleaned. The statutory test, you want to talk about the law. Ordinary wear and tear accepted. Dirt is not ordinary wear and tear. It's not dirt. Dirt is not ordinary wear and tear under a dictionary definition, under the case law we've cited.
It does seem to me you
wouldn't want the next tenants coming in to an apartment that hadn't been professionally cleaned.
Right, and I understand the argument you're making, the sort of free market economics, and you're right. I mean, that some of these things result in increased rents. but that's the trade-off the legislature chose. All tenants are going to have to pay increased rents because of these obligations we're putting on landlords. But here, doesn't the law say that you can only charge if it goes beyond ordinary wear and tear? And here, the landlord is charging for a carpet cleaning even if the carpet's immaculate when the tenant leaves. So why doesn't that conflict with the statute?
Well, that's not the facts of the case, the immaculate. I think the issue is near immaculate versus immaculate. We're looking for immaculate. And Joe Clark's testimony is clear that he would, he does assess it on case-by-case basis. In this case, there were dark patterns on the carpet, there were dust balls in the corner, and Jeff Clark testifies he would not have walked on the carpet. He was there personally. He would have not walked on the carpet without shoes on. That is not something you want the next tenant moving into, and that next tenant might be a family with kids. And so having the inbuilt mechanism of the carpet cleaning provision at below market rates is a good thing for tenants. And here's the point. They agreed to it, and it's not prohibited anywhere in the Landlord-Tenant Act.
Let me go back to this vandalism thing. Say someone came by and torched the place, burned it to the ground. Under this lease, does the tenants have to replace it?
Under this lease, first of all, that's a hypothetical question. It's not the facts of the case.
But you're going to have to apply this uniformly once we take your position. Now, so the question is, if someone commits an act of vandalism and burns the place down by torching it or throwing a Molotov cocktail at it, under this lease and in your interpretation of the statute, does the tenant have to replace the building?
I would say, as a legal matter, under this lease, under this landlord-tenant law, yes, that's probably true. They do have an insurable interest. It's a conveyance to the tenant. The tenant has an insurable interest.
In the premises or just the use of the premises?
I think in the premises. I
But
think
your position is
you're conveying that property and the premises. So I believe that's an insurable interest. Although that record, again, this is a hypothetical. That record is not made in this
That's
case.
a legal question.
It seems to me that seems to me to go way beyond specified repairs in the statute. That would be replacing the whole building. That seems to me not allowable. But as far as the obligation to repair specific damage that is neither the fault of the tenant nor the fault of the landlord during the term of the lease, is it your position that that's encompassed within specified repairs, that obligation can be shifted to the tenant?
Okay, the specified repairs is for single-family residences. That's what Judge Baumgartner found, that these were specified repairs, and I think she was correct to that extent. Here's the issue you have to get to before you get to that. Is it prohibited? Is it prohibited? Is the cost shifting prohibited? Mr. Warnock makes the case about performing the repairs. Well, that doesn't get to the cost shifting. The statute is silent on the cost shifting, and because it's silent, it's allowed. Now, on the single-family residence, that just makes it all the more so that Judge Baumgartner got it right.
Could I ask a quick question on the carpet cleaning? I see your time's up.
Yes.
Does it make a difference that this came out of the security deposit? And based on that, don't you have to comply with the requirements? So if, in a different case, the carpet is pristine, wouldn't that charge be in violation?
And we did comply with the statute. The notice was timely. It specified that it was carpet cleaning. Factually, if we lose on the carpet cleaning and you look at it and say, well, there was the testimony, but factually it was pristine, that's fine. Certainly doesn't make it bad faith on our part, right? Because remember, we got dung on bad faith on that. We think these provisions are really, really good, not just for landlords, but for tenants. And my time has expired, and I appreciate the opportunity to make the argument. Thank you.
Thank you. Thank you, Counsel. Rebuttal?
It's a little odd for me to hear these arguments that are supposedly good for tenants when my tenant ended up paying $598.
Let me give you a hypothetical.
Oh,
if you're right, let's try a different. Let me just play with it. If you're right, give you an example. My ex-wife moved to Washington, D.C., and she's over there for a number of years. She rented her house to an executive at one of the prominent Des Moines businesses who easily makes a six-figure salary. She doesn't want to be bothered in Washington, D.C., where she moved, my ex-wife, with dealing with day-to-day repairs. Your position would be she can't contract with the tenant to make repairs. Is that right?
I think the problem with it is that, we're just talking from a policy standpoint. I mean, more and more what's happening is these larger and larger companies are taking over the management. Actually, let me restart that. If we look at the individual tenants, are they able to make that kind of decision? And the legislature stepped in and said, look, here's a framework for doing this. I think that the downside of letting the tenants that are equal to the landlord, in your case, basically you're talking about an equal position, and they have equal resources.
Well, but statute doesn't have these equality provisions in it. I mean,
I think that's implicit in the
Well-
freedom of contract has been abrogated as
Well,
as far as a lot of provisions.
yeah,
And this prohibited argument, there's a lot of things you're required to do that are outside 562A11. You can't just say, oh, all we have to do is 562A11, and now it's up for grabs other than that. And the legislature has said, this is the framework we want you to follow. If you're going to be a landlord, if you're going to be a tenant, you're restricted in what you're able to contract. So I would say, yeah, basically they're going to need to set up a situation that's legal under the statute. And as far as arranging the repairs, it's not that hard. I mean, I think it's problematic for small landlords these days. This is a complicated legal setting they're in. The requirements they have to take care of for tenants, they have to provide a safe and habitable place for the tenant. And it's hard for them to do that. So I'm not sure, I don't think your case is that typical. And I would say, yeah, no, she couldn't contract with them for the major repairs. To say it's your responsibility, they could go to them and say, look, I'll arrange with you, we can make arrangements.
Really, and where in the statute do you get this distinction between the door and the snow removal and the
I think the
other
key
kinds
is,
of things?
my tenants could not perform that repair. They're not able to go find a door, to go stick it up themselves. I mean, I don't know if I could do that myself.
So
if I
what
could
the
hang a door.
statute reads in your view is that the landlord can contract for the tenant to perform specified repairs if the tenant is able to do so?
Yeah, I guess if I'm going to make my strong argument, it's that the landlord cannot contract away their essential duties, those first four sections, that the repairs and remodeling has to be other than their responsibility for habitability, for repair, for electrical systems, for plumbing. If you're an electrician and if you say, well, hey, I'd like to do a particular repair and you're capable of doing it, I think that's what that flexibility is there for. Really what this is used for, like I said, is mowing the lawn and shoveling the snow. And that seems to be the flexibility that's okay. And if you say to someone, yeah, you can handle the repair yourself.
So if it's a disabled tenant, you can't impose an obligation on them to mow the lawn or shovel the snow?
That makes sense, doesn't it? I mean, really, if they're disabled, to say you have to mow the lawn, and then they're going to automatically fail it.
It's a nice world, but it sure would make the law and the practicalities pretty complicated, right?
You know, I wish they hadn't made an exception to that general rule. We have to live with that. That they set up a statutory framework where the landlord is supposed to do the repairs. Habitability. I mean, the original Mies v. Fox talks about habitability and talks about the problems of the landlord not being responsible for repair. The landlord is in a much better position to do repair than the tenant.